Court is now in session. Please be seated.
Good afternoon, everyone. Introductions, please.
Good afternoon, Your Honor. Todd Schultz, Fager, Drinker, Biddle, and Wreath. Here with me today at council table from Aiken Gump is Pratik Shah, Julius Chen, and Kristen Loveland. And with us, Your Honor, in the gallery is Kristen New from AT&T.
Welcome all.
Mr. Shah will be making the presentation on behalf of the appellees.
Thank you. Mr. Goddess.
Jeff Goddess of Cooch and Taylor. I'm rising solely to introduce my colleague here, Mike Polera, a member of the Texas Bar. His pro hoc has been approved, and he'll be making the arguments.
Thank you very much. And we thank Judge Davis for also sitting with us today. You may proceed.
Mr. Chief Justice, members of the court, may it please the court, we're here today to discuss two contracts: the partnership agreement for the Salem Cellular Telephone Partnership and a management and network sharing agreement. There are two causes of action to which these contracts are relevant. One is a breach of the partnership agreement claim, and second is an entire fairness claim for valuation. AT&T, through an affiliate, exercised its majority power to buy out all of the assets of the partnership. When it did so, the plaintiffs sued, alleging breach of the partnership agreement and an entire fairness claim. The trial court found that AT&T had committed material breaches of both agreements. The trial court refused, however, to implement the contract remedies or to provide value for the operative reality presented by the management and network sharing agreement. I'll discuss that agreement and probably call it a MNSA, MNSA by its initials. It was easier than saying it over and over again. In both cases, the trial court excused AT&T from the consequences of its material breaches of duty on the basis of other material breaches of duty. I want to focus our attention on that today. The central issue presented is whether AT&T can be permitted to leverage one material breach of agreement using another material breach of duty. In addition, the court will be asked to consider whether the trial court abused its discretion by failing to shift attorney's fees to AT&T, an entity that the court itself described as the most obstructive litigant that he had ever encountered in his professional career, both as a lawyer and as a judge. First, I'd like to discuss the disassociation remedy provided by the partnership agreement. The disassociation remedy was triggered by a partner committing a material breach of the partnership agreement and failing to cure within 30 days' notice. The dissociation remedy provided that if a partner did in fact commit a material breach, then that partner would be required to surrender its interest in the partnership to the partnership and receive in consideration its capital account. This was agreed to at the inception of the partnership in 1988. It is important to consider exactly how that came about. This partnership arose out of a series of lotteries conducted by the FCC. Those FCC lotteries allowed individuals to buy an opportunity in the lottery, to form lottery pools so that if any one of them won an interest in the license, that everyone else in the pool would share in ownership of the license. Pursuant to FCC regulations, the party who won the lottery had to own at least 50.01%. And every other member of the pool could own only up to 0.999%. Everyone in the lottery pool knew from the inception that there would be a controlling majority partner and that the minority partners would own very small percentage interests. Because of this, it was a perfect negotiation. They were interested to make sure that the majority partner could operate the entity, but they were very, very cautious to make sure that the majority partner continued to abide by the obligations provided in the partnership agreement. And so this remedy was born. Because it was unknown as to who would be the majority partner, the same partnership agreements were used over and over and over again throughout the lotteries. A specie of this partnership agreement appeared in all 13 of the partnerships that were the subject of the litigation below. And the joinder of AT&T in each of those 13, they agreed at the time of joining to the remedy. With respect to the Salem partnership, at the time they joined, they were being sued in Galveston for enforcement of the remedy here. They knew the minority partners relied upon it. They knew from the experience in Galveston that in fact the minority partners would attempt to enforce it. The trial court found that AT&T committed material breaches of the partnership agreement. With respect to a titling provision, that is, that the assets of the entity would be in fact titled in the name of the partnership, the court found material breach, but refused to apply the dissociation remedy because, in the words of the court, there was disproportionality between the amount of damage sustained by the partnership and the value of the interest of AT&T in the assets at the time of dissolution, at the time at which we claim that the remedy should be exercised.
So for the disassociation remedy, is there some threshold below which it would not be appropriate to allow that as a remedy?
Well, the question has two sides to it, Your Honor. I believe that the threshold is there must be a material breach of the contract. And if there is a material breach of the contract and the breaching party does not cure within 30 days of notice, then you have triggered the right. But the remedy itself is a formula. It is not a liquidated damage clause that says when you do this, we're going to get this much money from you. No one knows what the values to be exchanged are until the moment of breach occurs and is triggered by the 30 days. Thus, you don't know what it's going to be in terms of how much money you're going to have to pay in order to get that remedy. In this case, what happened was that AT&T bought the assets and we deposited the money into the partnership. AT&T's capital account rose to the highest level it had ever achieved. They received approximately $215 million. That $215 million represents their 98% of the value that they paid to the partnership to buy the assets. It inflated their capital account. That is the capital account that we credit them for purposes of the remedy, highest in the history of the entity. The unfairness comes because after they filed suit in Delaware claiming that they had paid an entirely fair price for the assets and that the amount allocated to each individual partner's share was entirely fair for that share, they saw that the evidence would sustain a value higher than what they paid. The court found in the valuation opinion that they grossly underpaid for the asset. In fact, it's approximately 318% more than what they paid. That 318% represents what the court found to be the unconscionable amount of money that would be received. But that delta, the difference between what they paid and what the true value was created by their breach of fiduciary duty. They breached the duty of loyalty and paid too little for the assets. And when we seek to buy their interest in the partnership using the same formulas, they say, oh, no, 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 it's unfair of you to buy us at that price, when in fact, it's exactly the price they bought us at. They are using their breach of fiduciary duty to excuse themselves from the contract remedy. And as a result, one breach of duty is justifying avoidance of another breach of duty. That's not fair. Delaware is a contractarian state. We are entitled to enforcement of the agreement. Now, the trial court ruled that the reason that there was not a governance violation was because of a 1995 resolution that granted full, complete, and exclusive authority to the majority partner. That resolution existed. It was put in place. But the court ignored a 1997 amendment of the enabling provision of the partnership agreement, section 4.4, which said, if you're going to allocate any authority to a partner, you must do so pursuant to written contract. Specifically, the language of the agreement said, the executive committee may, to the extent it considers such action reasonable, delegate all or any portion of its responsibility and authority, leaving out extraneous portions, pursuant to written agreements to partners and or third parties, including affiliates of partners. Thus, it is, in fact, the agreement that supersedes. There is an integration clause in the partnership agreement. Once this amendment became a part of the partnership agreement, the integration clause caused it to supersede all inconsistent agreements. Then, in 2004, the executive committee adopted a contract delegating authority to AT&T, the MNSA. That contract provided for how they would manage and how they would account for the assets of the partnership. It was detailed. It was written by AT&T. The executive committee, composed of 3 people, 2 of whom were from AT&T, 1 of whom represented the minorities, voted for it and accepted it in the Salem partnership. And as Vice Chancellor Laster pointed out, they pervasively and persistently violated it. They violated it to such a degree that when we sought discovery regarding the traffic-based formula for calculating how to share revenue and expense, AT&T objected and said, we can't possibly provide this information. We didn't account for it this way, and it would be unduly burdensome. This led to a 20-month appointment of a special discovery master who rendered an opinion saying this traffic discovery is unduly burdensome. I believe him. I believe that AT&T so badly breached the MNSA that in fact they could not go back and recalculate the amounts that they owed.
Mr. Plera, to clarify your argument, do you disagree with the trial court's conclusion that a breach of the MNSA, as you call it, would be a derivative claim? Or do you disagree with the trial court's conclusion that the AT&T's conduct did not breach the governance provision in the partnership agreement?
Disagree with both, Your Honor.
Okay.
With respect to the derivative claim has relevance in the context of the valuation claim. What the trial court did, and it's kind of interesting, in the first opinion, he addresses the breach of contract claim for the partnership agreement. And he says the disassociation remedy is unconscionable because of a disproportionality. But there's no disproportionality because nobody knew at that moment when he is issuing this opinion what the value of the partnership was because he had not yet rendered the valuation opinion, which would come 6 or 8 months later. And so he is essentially saying, in the abstract, it is simply always unconscionable to have this kind of remedy. That can't be right. He analogized the remedy to liquidated damage clauses. But liquidated damage clauses, there was no attempt to try and calculate what the damages would be and then figure out a dollar amount. We're dealing with a formula. It's much more analogous to a prenuptial agreement in which the partners in the marriage agree that if one of them breaches trust, we will end this fiduciary relationship and you will get X. That's exactly what this is. It is a breakup of a fiduciary relationship because otherwise we are left in a relationship with a partner, in this case a dominant 98% partner, who cares nothing for the text of our contracts, but instead is breaching them willy-nilly, but because they've got a big interest, we can never bring them to heel. It is impossible for us to have a relationship that way. In the context of the dissociation remedy, what we're dealing with is a breach of the MNSA is the defined parameters of their authority. It says in the MNSA that there's nothing in this that gives them de jure or de facto control over the partnership or the assets of the partnership other than what's right here. There is no cocoon of greater authority which the court found to exist because of the 95 resolution. The 95 resolution went away because of the 97 amendment, and the MNSA itself has an integration clause which causes that to go away. In the context of the valuation claim, the MNSA is a derivative action is not necessary for 2 reasons. One, the MNSA created a right to a recovery in favor of the partnership against the AT&T affiliate. That asset had value. AT&T did not identify that asset and did not accord it any value in the PricewaterhouseCoopers valuation study, in its trial testimony, in its expert reports, nowhere. We are seeking to have that value recognized so that we receive our proportionate share of it. Number 2, the MNSA was the operative reality, and therefore, as the operative reality, the provisions of the MNSA should have given us this higher, better price. It's a bigger percentage of a bigger pie is the way the MNSA operates. And so we never got this. Now, in light of the fact that AT&T operated the partnership in such a way that they could not ever come back and tell us what was the shared revenue, what was the bits and bytes compared to theirs, our percentage of their shared revenue, our percentage of their shared expenses. There is 2 factors that we're looking for: a 25% premium on revenue and a 10% discount on sales and marketing expense. This is provided for in the MNSA. Vice Chancellor Laster identified it. He said we were entitled to it. He said it was the operative reality. And with respect to the discounted cash flow value of it, he actually calculated it and then did not give it to us. There's no explanation, no rationale, nothing is provided. It is a single paragraph in which he says, with the premium and discount, it would be 900 plus million. Without it, it is 700. I give you 700. But it's the operative reality. What we're dealing with, Your Honors, is a circumstance in which the court chose to hang its hat on the 95 resolution when no one in the case over the course of 10 years did that. AT&T claimed that the sole source of its authority was the MNSA. AT&T claimed that that was where they got their rights to do what they were doing. They never claimed that it was amended. They simply didn't know what it said. They had executed it and put it in a file cabinet, and the man in charge of partnership accounting and partnership relations recognized he just didn't know what it said and had operated under the traditional accounting system. By virtue of his selection of the MNSA for pursuit in a derivative action, what Vice Chancellor Laster has done is he has relegated us to AT&T's phony accounting system, counting subscribers who are all over the country but happen to have a phone number that was issued from that market, and counting roaming charges when the MNSA eliminates roaming charges. And thus we're in this netherworld in which the MNSA is the operative reality, but we get no benefit from it because instead of looking at it as an item of value, he looks at it as a cause of action that we would have to sue on. Nobody disputes that the MNSA is the operative reality. Nobody disputes that it is due to us.
Thank you very much.
Thank you, Your Honor.
May it please the Court, Pratik Shah for the AT&T defendants. Unless the Court prefers otherwise, I'll start with the claim for the breach of the partnership agreement's governance provision because that is what the disassociation remedy is premised on. If there's no breach of the governance provision, the disassociation remedy doesn't come into play. That's in their own question presented on page 11. They said whether AT&T breached the governance provision by breaching the management agreement. That's the question. The fundamental problem with plaintiff's bootstrapping contract claim, which both sides agree is predicated on the management agreement, is that it's not independent of an injury to the partnership. And therefore, it constitutes a derivative claim, not a direct claim. That conclusion follows directly from the structure of the two agreements themselves, and more importantly, from this Court's framework for distinguishing between direct and derivative claims laid out in the Tooley, El Paso, and Brookfield line of precedents, which plaintiffs never cite in their briefing or even at argument today. Of course, this Court has spent the last 2 decades providing a framework to simplify, refine, and determine when you have a direct claim versus a derivative claim. And as this Court said in El Paso, at page 1260 of its opinion, and of course El Paso involved a breach of a partnership claim, breach of a partnership agreement. What this Court said is the partner can prevail. There's only a direct claim if that direct claim can prevail without showing an injury to the partnership. But by definition, because their claim here for breach of the governance provision is predicated on a breach of the management agreement, it can't be independent of an injury to the partnership. The management agreement is an agreement between the partnership and a manager, and the harm from a breach of that agreement flows first and foremost principally to the partnership. And so under this Court's very straightforward test in Tooley, Brookfield, and El Paso, this has to be a derivative claim. That's what the Vice Chancellor concluded, and that cuts through everything in this case. They don't have a direct claim for breach of the governance provision for that reason. There's no serious contention. They've never made the contention that the injury from breach of the management agreement flows to the partnership. It is therefore a derivative claim. Now, what they say is it's both, right? It's derivative and direct. But this Court overruled that line of reasoning, starting in Tooley and then finished the job in Brookfield just 2 years ago when it overruled the Gentile case and says, no, we're not going to have these dual claims. You have to show it's independent of the entity, whether it's a corporation or a partnership. And you can't, of course, it also injures the minority partners, but that was true in El Paso. And this Court made clear that's not enough. However, that did not leave them without a remedy. The lack of a direct breach of claim did not mean that they couldn't recover. The trial court awarded plaintiffs millions of dollars on their breach of fiduciary duty claim to make them whole and to ensure that AT&T did not profit from the breaches. Although AT&T is an appellee, in this court, it lost on that fiduciary duty claim. It was hit with a damages award amounting to up to $62 million across the relevant partnerships, roughly doubled with interest, and that's not even including the settlements paid to other plaintiffs. Unlike the breach of contract claim, the fiduciary duty claim does not depend on any injury to the partnership, and it thus constitutes a proper direct claim on which the trial court can and did award full damages relief, giving the plaintiffs the benefit of the doubt at every step during that valuation. That is precisely the result that this court contemplated in Brookfield just 2 years ago, and plaintiffs should not be entitled to a windfall of billions more, $2.65 billion across the partnerships, again doubled with interest, under their preferred disassociation remedy, which only flows here from a derivative claim, which everyone agrees they cannot bring. And so that's sort of the landscape of this case. I'm happy to talk more about the derivative versus direct claim, but I think that is very straightforward under this court's line of precedent under Tooley, Brookfield, and El Paso. And by their very terms of their argument, their question presented says their theory of this case is that the governance provision is breached only by a breach of the management agreement. That ends their case, because a breach of the management agreement is an injury to the partnership. The minority partners are not even a part of that agreement between the partnership and the manager. I'm happy to talk about the fiduciary damages issue. Now they say that the Vice Chancellor erred by not giving them the 20% premium and other provisions within the management agreement itself. But their own experts, plaintiffs themselves, advocated for a different approach, and the Vice Chancellor, in his opinion, says, I'm going to adopt plaintiffs' approach. Now, there's a good reason why the Vice Chancellor and all the experts didn't use the management data, and that's because on page 5 of the Vice Chancellor's opinion, this is the first contract opinion, he says, quote, plaintiffs failed to develop the factual record necessary to estimate how compliance with the management agreement methodologies would have affected the value of the partnership. So what the Vice Chancellor did, as this court has instructed, is do a valuation from the ground up, trying to estimate the value, what would have been the full value of the partnership at the time of the dissolution. And he used the approach that the plaintiffs themselves proposed. He did a DCF analysis. It's a painstaking 35-page analysis going from page 97 to 131 of his breach of fiduciary duty opinion, and he goes through each and every variable, each and every input into the DCF analysis, and when there is doubt, he resolves that doubt in favor of the plaintiffs. As the case law says, it's designed to make them whole and to make sure that AT&T didn't profit. Over and over, he chooses inputs that would make sure that plaintiffs were made whole. And so our position is, look, that they already have the Vice Chancellor has already overvalued the partnership in favor of plaintiffs. It's 3.5 times the valuation that AT&T put forward. Now,
Mr. Shaw?
Yes.
Just really quickly on
Sure.
it. Are you saying that page 5 of the contract decision is what connects with page 131 of the valuation decision?
So in the valuation decision, so the breach of fiduciary decision, the analysis really starts at page 97. And in those first 4 pages or so, before he starts going through the actual calculations of each of the inputs, he explains what approach he's going to take. And he says, look, I don't have the information to do the management agreement methodology. And you can reference, and that statement is most plain in that first contract decision on page 5. And so he says, I'm going to adopt plaintiff's approach, which is to do a DCF analysis, right? And he says, I'm going to use inputs and I'm going to do my best to make sure that their value, they're not harmed, and that AT&T doesn't profit from the breaches. And he does his best job over the next 35 pages of doing that.
So in page 131, where he says that valuation would not have accorded any value for these 10 to 20%, that relates back to the contract decision at page 5.
Yes, and really to the entire 35 pages, because it's really mixing apples and oranges, right? What he's saying is, I am doing this DCF input analysis, right? I'm trying to come to what the full value of the partnership, what they would have been entitled to had there been no breaches at the time of dissolution. I'm not using the management agreement because I don't have those inputs for whatever reason, right? He says it's because plaintiffs didn't develop the record. I'm sure they'll say it's because they didn't get discovery. But whatever the reason, he didn't have the inputs, so he did his best job to come to the number. Now, as you point out, Your Honor, he didn't then go back and add a 20% premium because those premiums were tied to the inputs in the management agreement. So it would be mixing apples and oranges. You can't do a full different analysis based on different inputs and then just borrow the features of the management agreement that you like. Now, it is a little bit confusing because you're right, on page 131, he has this last paragraph, which Appellants Counsel alluded to, where he does say, I'm going to adjust it upward 20%. What he was doing, if you can see, that last section follows the first 30 pages where he does the full analysis and says, I come to a number of about 700 million. He then says, I'm going to do a reality check, right? That's on page 128, 129. And then he basically pressure tests it against 3 different methodologies. First, he says, I'm going to compare it to the T-Mobile bid. And he says, look, for reasons that T-Mobile bid isn't a good barometer, so I'm not going to knock it on that. 2 is, I'm going to look at plaintiff's expert valuation, basically doing a projection from the 2009 present value calculation. He said that comes to about a $571 million valuation of the partnership. My number is bigger than that, so it seems it should be at least in the ballpark. And then the third metric he used, Your Honor, is the one that you're mentioning, which is, what if I adjusted this 20% upward using the management, and then I come to a number about $900 million. And again, the $700 million range is in between the $571 million, the $900 million, and so he says that's the number. That's really all that he's doing, as best we can tell in that last section. He's not throwing on the junk pile the entire analysis he did in the prior 30 pages when he says, I can't use the management methodologies. I'm going to build my own methodology using the plaintiff's approach, using the best inputs that I have, and erring on the side of the plaintiffs. The standard, of course, as this court knows, is that damages award outside the bounds of reason. I just don't see how you could come to a conclusion that that damages award, where the Vice Chancellor went out of his way to err on the side of plaintiffs, could be found, that detailed analysis could be found to be outside the bounds of reason. Obviously, we bought a contingent cross appeal that in the event this court did want to reopen it, then it should look at the aspects that we felt in which the Vice Chancellor went overboard, and that's the tax affecting. He used a 0% tax rate. Obviously, you don't reach that if you don't reopen the damages award. But just to say a moment on that issue, even the Vice Chancellor recognized that that would have significant implications on the order of about 30% for the damages award. It would knock it down by that amount had you applied the tax affecting rate. We think it's pretty clear, if you agree that open MRI is the presiding precedent, that should prevail. Again, that issue isn't reached unless you reopen the damages award. I'm happy to answer any questions about attorney's fees or other issues.
Just one,
Yeah.
as I understand it, this case is a bellwether case, right?
It was, yes, it was designated as the lead case among 13 partnerships. I believe there's 11 other partnerships now remaining after the settlements.
So this decision potentially impacts the outcome of all of the other ones?
Yes, the 11 other ones as to the, that's right, as to the fiduciary damages awards.
And on the attorney's fees, that shifting applies in an extraordinary case. And based on the Vice Chancellor's comments, why doesn't this one fall into that category?
Sure, right. So it's an extraordinary case where there's bad faith. And the Vice Chancellor was in the best position of anyone here to determine whether there was bad faith. In fact, plaintiffs have relied on the Vice Chancellor's own comments. And what the Vice Chancellor said in denying attorney's fees awards is, this didn't actually rise to the bad faith that you need in order to do it. And recall, Your Honors, that the Vice Chancellor here did, because discovery was admittedly very contentious, the Vice Chancellor did appoint a special master to handle discovery. And the findings of the special master were that AT&T acted in good faith and it in fact denied the discovery ultimately that plaintiffs were seeking. So the vice chancellor was obviously in the best position. They're relying on his comments, and the vice chancellor himself said, no, this doesn't rise to the sort of case that would merit that extreme finding of bad faith to award attorney's fees, and therefore that is not an abuse of discretion. I don't see how it can be when he's assessing his own words, and so we would respectfully submit that denial should be affirmed.
Thank you very much.
Thank you, Your Honors.
Your Honors, it is inaccurate to suggest that it is necessary to prove that there was a breach of the MNSA that resulted in injury to the individual partners in order to define the MNSA as the four corners of the authority granted to AT&T to act on behalf of the partnership. The injury to the partners, the injury to the partnership, is that you have a renegade general partner acting on behalf of the partnership except through the executive committee. And that is exactly what happened. We had persistent, pervasive breaches of the grant of authority. Do we have to prove that we sustained a monetary injury or that we are seeking to recover the monetary injury derived from that excess? No. We need only prove that that's the four corners of their authority and they've acted beyond it. We're dealing with a general partnership. Literally every partner has the authority to act fully on behalf of the partnership. How do you control them? This is the sword of Damocles hanging over each partner's head. I must comply with the partnership agreement. I must act only through the executive committee or only within the four corners of the agreements that the executive committee executes for me. And if I do otherwise, I will lose my place in the partnership. I will deliver my interest. I will then exit with my capital account in my hand. It is wrong to suggest that what we're dealing with is some kind of a windfall. The way that the remedy was originally designed to operate was that if you breach, you exit the partnership, your interest is prorated among the remaining partners, and the business continues. But because the business has been wound up by AT&T buying the assets, we seek the economic or financial equivalent of the remedy. The court accepted this below, and that decision hasn't been appealed by the other side. What we're dealing with is a circumstance in which AT&T would be required to buy the value of their interest from us at the reasonable fair price that the court determined to exist. They've got the assets right now. After they pay us, they'll have the assets. There is no windfall. They're just paying full value for the assets that they bought. And in this way, we recognize the benefit of our bargain from the partnership agreement. What we're dealing with in the MNSA, it's a 25% premium, a 10% discount on sales and marketing expense. What we're dealing with in the MNSA is the benefit of our bargain for those aspects which are readily apparent in the record. AT&T doesn't get to say, we so massively breached the agreement that you are not able to do the calculation, because that's what happened. And therefore we get to use our preferred method. Did my experts do that? My experts used it because at every step when we tried to get the discovery, we could not. Now, there's a suggestion that just because Vice Chancellor Laster concluded that he didn't find bad faith, that therefore we're bound by that at this level. But that would suggest that this court has no right of review over the decisions that are made. The attorney's fee shifting, as the court noted, is an issue of, are they injuring the process? Do we want to encourage this behavior? I would encourage the court to look at the opinions and to see how many times the court had to go back with the same orders and explain to counsel, I'm really serious about this. You really must do these things. One of them involved the court ordering discovery, and 2 weeks before trial, they remove us to federal court where we sit for over a year. The question is one of, do we have the right to enforce the agreements? Do we have the right to enforce the partnership agreement? Do we have the right to the benefit of the partnership's agreement with the AT&T affiliate for operations? Is Delaware going to enforce the agreements for value? Even though we're not suing on the MNSA, we just want the value of the MNSA. Is Delaware going to enforce the parties' agreement made with an entire staff of lawyers in which AT&T consents, and then they come forward, they breach it, and they say, yeah, but that's a lot of money. Well, that's right, but they got that value.
Thank you very much.
Thank you, Your Honor.
It says rebuttal. Not sure that it was really brought up, but.
Sure, Your Honor. Yeah, my understanding is the rebuttal is limited to the cross appeal. I'm
It is.
happy to answer any questions about the cross appeal if there are any.
Thank you very much.
Thank you.
Counsel, we appreciate the excellent arguments. We'll take the matter under advisement. Please recess the court.
Please rise. Hear ye, hear ye, hear ye. All manner of persons having anything to bring before the Supreme Court of the State of Delaware may now depart and give their attendance to the call of the court. The court is now adjourned. God save the state and the honorable court.